The T-Row Show. Transmitting truth. One week at a time.
Welcome to the 10th broadcast of the T-Row Show. We hope you like our new jingle. It's going to be on every one of our recordings from now on. This is your host, Keith. We got Tony and Stu. Say hello, guys.
Good afternoon.
Hello, everyone.
All right, here we go. Now, this is going to be a series we're starting because there's a series in the Rain of Heaven Society Post called National Security Breach by Creatures of the State. And it's an 8-part series that we put together back in February of last year. And it went through February and I think part of March. And we were doing a series on lawyers. And it was sparked by the CBS News clip about a New York City attorney that was claiming we run the country. He says we make the laws that benefit the lawyers. And he was bragging, and he was on a, he was being videotaped secretly type thing. And we decided to go ahead and go through and check out a lot more into this particular subject because they only covered the surface of that subject and not necessarily went into the whole idea of it. Now, this series is going to help you understand exactly what happened while everyone was asleep, while everyone was going on vacation, while everyone was, watching TV, watching ball games and all this kind of thing. What happened to your country? Why don't you have any influence on any laws or statutes within the states? Federal or otherwise. Why don't you have anything there? What's going on? Who's responsible for the mass immigration? Who's responsible for all these things? And these guys, they kind of stay in the background and hidden. And we're going to show you, you think you'll understand it. You'll think, oh, this is just going to be bashing lawyers. This is not what's happening at all. What we're doing is trying to impart an idea on how this happened and how the title of nobilities clause was twisted and turned, how all these things came about. So we're going to be reading this to you from the newspaper, and there's we'll try to get through to part 1, 2, and 3 today. Not sure if we'll get that far. But like I said, there's links all through this thing, this whole series. It takes maybe, a day or so or two to go through if you have that kind of time. But we'll just do it in an hour show, and hope you enjoy it. So here we go. All right, the first one is just Creatures of the State, National Security Breach by Creatures of the State. There's a 27-second clip. You can read that, or listen to that. And it reads, many people have claimed that the no titles of nobility clause within each state constitution means that no one is to accept a title of nobility from any king or prince or potentate or anything like that. It says that that may be correct. However, the clause within each constitution is not adequate enough for what you are about to see within this presentation. And here's a famous quote. It says, because of what appears to be a lawful command on the surface, many citizens, because of their respect for what appears to be law, are cunningly coerced into waiving their rights due to ignorance. And that's an older case, but you can look it up. All right, we figured out that the Constitution cannot enter into any courtroom because of this clause. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of the Congress, accept of any present emolument, office, or title, or of any kind whatever, from the king, from any king, prince, or foreign state. Okay, many people concentrate on the word title and never look up the word nobility. In order to understand this clause, it is to look at it in reverse. Now, nobility is an order of men in several countries to whom privileges are granted at the expense of the rest of the people. In other words, the laws don't apply to them. They're able to enforce the laws, but the laws don't apply to them. That's called a nobility. They don't apply to the people that are enforcing the laws. As we have said before, to change an entity is to change its form. The word state is not the same as the word state, which is in all caps. So state in upper and lowercase letters is not the same as the word state in all uppercase letters. Okay, so the main issue is whether a man can plead for another in any cause for a fee. Keep in mind there, the main issue, and that's what this was all about, is whether a man can plead for another in any cause for a fee. So when the country first started, this practice was prohibited. Then expanded to friend in counsel, where a fee was also prohibited. That's huge, by the way. That little statement right there is enormous, because no one, in any way, shape, or form, when this country started back in the Declaration of Independence and then the Articles of Confederation, no one could plead for another in any cause for a fee. You couldn't pay somebody to go show up in court for you. It was strictly prohibited. Then expanded to friend in counsel, where a fee was also prohibited. So everybody says, well, I'm a friend in counsel. I'm here helping, this guy. And they're automatically, you can't practice law without a license, okay? They're automatically attacked because this private membership association called the bar has to protect its commerce, itself, and it went that far, and that's how it got in, was through the pleading of another for any cause for a fee. That was the issue. So nobility and titles of nobility didn't stop it. What did they do? They changed the issue, or they changed the argument, and then turned around and said, oh, let's put this in, meaning we have to overturn where a man can plead for another for a fee. That was the issue. That was slipped in without anybody seeing it and noticing what was happening. Then the practice expanded to where someone could plead for an entity and represent it. So the entity couldn't speak, so they had to have somebody plead for the entity for a fee. That's how they got in. Then the corporation became a natural person under definition. Then it became a practice to plead for the individual. This happened over many years by statute, not by any constitution. The practice is called creatures of statute, also known as creatures of the state. The practice are legal entities such as corporations created by statute. Creatures of the state may include municipalities and other artificial legal entities or relationships. Thus, when a statute in some fashion requires the formation of a corporate body, often for governmental purposes, such bodies, when formed, are known as creatures of statute. The same concept is also expressed with the phrase creature of the state. Okay, so we're not making this up, guys. The states absolutely acknowledge that they're creatures of statute. We're not creating that term, creatures of statute. That's a quote from the states. So the term creature of statute is most common to the United States. Many people already know that the United States is not the same as, in other words, the United States in all caps is not the same as the United States. So that would mean that the United States is a creature of statute. So that is huge when we're talking about this, okay? I'll read that again. And that's the concept that everyone is going to need to really understand. So you have term creature of statute is most common to the United States. That's Manhattan Island. Okay, they create creatures of statute. Many people, what's that?
That's upper lowercase, the United States.
Yeah, upper lowercase United States. Okay. Many people already know that the United States, all uppercase letters, is not the same as the United States, upper and lowercase letters. So that would mean that the United States, all uppercase letters, is a creature of statute. So they took United States, then by statute created a completely different United States. That's what a lot of people are not understanding.
This is on paper.
Yeah.
This is not land. This is not land mass with borders and things like that. This is bureaucracy. This is paperwork.
That's why they call him a creature of statute. Okay. Yep. So a bunch of body politic got together of lawyers. Okay, and on paper they created a completely different United States within the United States. That's how it operates. So you have a United States, and by statute created a United States within the United States. So there's two separate United States. So the importance of a corporate body, regardless of its exact function, when such a body is a creature of statute, is that its active functions can only be within the scope detailed by the statute which created that corporation. So if you have a court within a court, which is what happened, you have your regular court, so the title on the front of the building will have the original court there. So you're thinking you're going into the original court. You see where I'm coming from? And they didn't change anything there. They didn't do away with the states, the original states. What they did is they created a court within that court, but they created it by statute. And its functions can only be within the scope detailed by the statute which created that corporation. So you have to go into the statutes and find where a particular court was created, and usually it's in all capital letters, and then you have to find the scope, because a lot of times, this was the weird part. I was watching a legislature channel one time, and yeah, it had a lot to do, right? Sit there and watch a legislation channel. I mean, you just want to gouge your eyes out because it's so exciting. So they created this court, and it was a fat bill. And it's literally called a fat bill. I'm not kidding. And it was dealing with the amount or what the kids were eating in schools. Okay, to get rid of these, the chips and the cookies and all that kind of thing, because they say, oh, the kids are getting too fat. So they passed the bill, and the court that had the authority to hear it was in one particular county, and that was it. That was the only court that was allowed to hear any case about the fat bill. So you could be... go ahead.
That was the scope in the statute?
That was the scope. There was only one court allowed to hear that case, that had authorization to hear the case on that particular statute that was passed, or the act, or whatever they wanted to call it. But they don't tell people that. So you try to sue them in a completely different court, and the judge says, dismissed. And they go, why? And nobody says a word. Because you didn't go to the right court. They just, well, you need to get an attorney to explain that. Well, the attorney's not going to tell you that. They will never tell you what you were just told just now. So you have to look at the statute, and you have to go find the court that has the authority to hear the statute. That's how messed up this is. And this is why creatures of the state are a national security risk.
Say that again.
That's why creatures of the state are a national security risk.
That's right.
Because you have a private membership association that has hijacked the law of the country. That's why nobody can figure out if they have an oath and affirmation. Nobody can figure out if they're citizens. Nobody can figure out anything. It's nothing more than confusion. And it makes sense to the guys who did it, but it only benefits them. That's it.
That's the nobility.
We'll get into the nobility here in a minute. All right. Thereby, creature of statute is a tangible manifestation of the functions or work described by a given statute. So the jurisdiction of a body that is a creature of statute is also therefore limited to the functional scope written into the laws that created that body. Unlike most private corporate bodies, creatures of statute cannot expand their business interest into other diverse areas. Y'all get that? So you have a private company. A private company can open up departments and expand and do this and do that and blah, blah, blah. People are associating those private companies with creatures of statute, which are two separate things. Completely separate things.
So if I've got it straight, if a statute is created, if a statute is used to create a court, that statute's going to spell out what that court can hear. If it can only hear employment discrimination issues and it tries to hear a foreclosure case, it's violating the statute, correct?
You got it. A functional scope. It's outside of its functional scope.
Which is why it's dismissed.
If it doesn't benefit them, they'll dismiss it. But
Right.
if it does benefit them, they'll hear it and never tell you that they've gone outside their business interests.
Right. So it's a systemic fraud, really.
And then the PMA actually decides that case even before the court hearing, writes it up in the meeting minutes, and the court hearing is just a formality.
As far as I've witnessed, as far as I've seen, yeah. They'll come out with decisions. They already have it all made out. Everything's already done. You're already guilty, and then they're actually sitting there discussing. A judge will sit and discuss with the prosecutor what the fines are and everything, and they're going to work it all up for themselves. Now, keep in mind that that's a little private. It's a creature of statute. So they have to, any money that comes in only benefits that particular statute. Basically, what you're looking at is illegal as hell. But, that's my opinion.
Well, just the mere fact that they created a state within a state violates the law of nations. So from there, everything just gets worse. It snowballs.
It's really bad. Let me go over that again so people, I'll just go over that one paragraph, and then I got another paragraph below. But the importance of a corporate body, regardless of its exact function, when such a body is a creature of statute, is that its active functions can only be within the scope detailed by the statute which created that corporation. Thereby, the creature of statute is a tangible manifestation. That's tangible property. And we're going to all of a sudden manifest ourselves. Okay, it's manifestation. It appears, okay, of the functions or work described by a given statute. The jurisdiction of a body that is a creature of statute is also therefore limited to the functional scope written into the laws that created that body. Unlike most private corporate bodies, creatures of statute cannot expand their business interests into other diverse areas. So the court that was created or assigned to a particular statute cannot go outside of the scope of that statute or that assignment. Where another corporation, say a large corporation, just for instance, no reflection on who they are, Target can have many departments and many expansions into entertainment, clothes, kitchen, bedroom supplies, bed supplies, all that. They can expand into all those things. But if their corporation was a creature of statute and they said Target can only sell televisions and electronics, then that's all it can sell. Has to stay there. Cannot expand into anything else.
Yeah, just a real-world type of application here. So this is where you could get a court document in your mailbox, and it says, and I'm just kind of making this up, but it says, County Circuit Court, and then, the writing, and then the bottom, the letterhead, it says Circuit Court for blah 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 county. So you've got two different names on the same document. One is the mailing address, the shipping address, which is the building, but the other is the court operating within that building. It's a different court.
A creature of of statute.
Right.
It was created completely by statute, has no constitutional authority whatsoever.
Right. Did that was that clear? What I was.
Oh yeah.
Yeah. So they're playing. Again, we're back to, and we've emphasized this before. We're back to the name name game. The capitals, the upper and lower case, the lowercase names that sound alike. United States of America, the United States of America. It's all so diabolically deceptive. It's really shameful.
I see at least 20 examples of confusion per week in emails alone.
Yeah, I don't doubt it.
Of that not understanding this part of the way the country has developed. Okay, they don't get it. They don't understand it because they don't pay attention to names. They don't think there's any differences in them. But once you understand it, it's very easy to pick out a statute, and it's also easy to pick out a constitutional. It's easy to pick out this, that, or the other thing. All you got to do is go check it. I mean, how many people literally read the county charters or the city charters of any given organization or municipality or anything? Nobody ever reads anything.
How many people know that city charters exist?
Yeah, I mean, really, I don't get to that, but yeah, true. A charter is a constitution, guys. So in case anybody didn't know that, that's what it is. Okay?
Yeah, and that's part of them being involved in the education system and keeping that stuff from the public at large.
Right. Now, listen, this is a real important part here. This means that if the creature has within it attorney's fees, then it's required to pay attorney's fees. If the creature has within the statute that persons can be represented, which is implied by the term attorney's fees, then we know that the Constitution did not authorize its creation and therefore has been created by a privileged class of people. I'll read that again. This means that if the creature has within it attorney's fees, meaning they have rules in there that enforce attorney's fees, that it is required to pay the attorney's fees. Okay? If the creature has within the statute that persons can be represented, which is implied by the term attorney's fees, then we know that the Constitution did not authorize its creation, and therefore has been created by a privileged class of people. A bunch of guys got together and created it. They had enough leverage to go into the state legislature and pass it.
Right. Right. Stipulating that they would be paid.
They added in their own fees.
Yeah. Mm-hmm.
Which was strictly prohibited in the beginning of the country, because they knew what kind of crap this would do. It was strictly prohibited from doing that. So who overturned that? They didn't overturn it. That's the whole point. That was never overturned. When it was strictly prohibited from walking in and pleading for another man for a fee. Strictly prohibited for doing that. Or
and of course and there's a good reason for that. Pleading, not being allowed to plead for another person because, free speech is critical. Communication.
Absolutely. It threatened free speech.
Right. As we see today.
Oh, yeah, big time. Okay, example. There's an example in here. The state of Florida, all capital letters, state of Florida, is a creature of statute and not the state itself. Therefore, the creature is represented by a prosecutor that is a member of the bar and is paid a fee for the representation of the creature of the state created by statute and not authorized by the state of Florida Constitution itself. I'll read that again. The state of Florida, all capital letters, is a creature of statute that is not the state itself. Therefore, the creature is represented by a prosecutor that is a member of the bar and paid a fee for the representation of the creature of the state created by statute and not authorized by the state of Florida Constitution itself. So when they're referring to the Constitution, they're referring to the like state of Florida, the original state of Florida Constitution. And then they refer to the fact that the state of Florida Constitution can create statutes, pass laws to govern itself, and they didn't specify in there that you couldn't create another state of Florida or a corporation or a creature of statute. So they just went ahead and did it. Further, an enactment clause in the name of the creature is for the creature itself and not the enactment of the state. So when you see these things that have an enactment clause, meaning being enacted by the legislature of the state of Florida, in all caps, this is what it reads. Being enacted by the legislature of the state of Florida, that's upper and lowercase letters. That is the enactment clause, and that's all the enactment clause ever was and ever will be, and it's not changed. Now what happens when you do this? Being enacted by the legislature of the state of Florida, then you put it all in all capital letters. You change the enactment clause by statute and place the creature under a title in the name of State of Florida or FL, which is the state code. Then you have a sheriff out there that has pledged himself to uphold state statutes, and therefore pledged himself out of his own office. So he's upholding the creature of statutes, those statutes under that creature, which makes him, all that. Well, under that creature, he's pledged himself to that and has completely bypassed the original state.
And left his office abandoned.
Right. So the way to actually fix that is to have an oath and affirmation or oath or affirmation of office that specifies original state of. So he can, he swears to uphold the law and blah, blah, blah. He can raise his right hand and say that he takes an oath and affirmation to uphold the original Constitution of the state of Florida. Then the lawyers have no authority over him whatsoever. When he pledges himself to uphold the laws of from within the creature that was created by statute, he's abandoned the original state. And therefore his office is by statute only, not by constitution. So there it is.
Some hard-hitting statements.
It's heavy duty, man. It is heavy duty stuff. And there's an 8-part series on this, guys, that a lot of people missed. Okay, this clause is a part of the statute which indicates the legislative authority by which the statute is made and its effective date. Some state constitutions specify the enacting clause for legislation, and such legislation becomes void without the enacting clause. Generally, enacting clauses appear in historical or legislative notes in codifications of statutes. Okay? So, whoops, some state constitutions specify the enacting clause for legislation, and such legislation becomes void without the enacting clause. What could this mean? Could it mean that the creature of statute was created on paper? Could it mean that all statutes created under another enacting clause could be for the benefit of a privileged class of people and no one else? The lawyers never accepted any titles of nobility, and I'll tell you that is huge right there. They never accepted any titles of nobility, guys. And there was a whole movement on that. That they have titles of nobility. They never did that. What they did was create a nobility under a title, using a creature of statute, thereby never accepting a foreign title.
That is slick.
That's a mind twist right there. Okay?
Yeah.
There was not any clause in any constitution that forbids creating a nobility under a title, creature, created by statute. However, there is a law that forbids creating a state within a state, which is what the lawyers violated. Okay? So, what they did is they created, by statute, they created creature of the state of Florida, which is all capital letters. Then they created themselves a nobility under that. So they could prosecute, and nobody could prosecute them. All you can do is write complaints to the Bar Association about them.
Sounds like a privileged class.
Okay, so they made it to where, well, you write a complaint about me, big deal. I don't go to jail. So the lawyers that have figured this out will violate all kinds of things. They can never be charged with anything because they are the ones that wrote the law. And they made it to where it doesn't hurt them at all. They're immune to it. That's called a nobility under a specific title. They just did it by statute. The state was created on paper and therefore is a mere image of the original state. However, has real-life applications and consequences in its enforcement. Now, does this famous quote make sense? Okay? Because of what appears to be lawful command on the surface, many citizens, because of their respect for what only appears to be a law, are cunningly coerced into waiving their rights due to ignorance. The state constitutions do not recognize anyone pleading for another in any court case because people have the right to face their accuser, not their agent. That is why constitutions are not allowed in any court, because it null and voids the lawyers within the court trying to practice law which is not recognized by the state constitutions or any constitution of the United States of America. The people are not recognizing as having access to any state constitution because they are without an oath or affirmation to it and are considered denizen and banished from the state. The statute at large for the state of South Carolina. I'll just read this off. Oath of allegiance to the state, required by amendment of the Constitution of all officers of the state. Okay, they had to amend it to expand it to the officers, December 6, 1834. Oath of to be taken by aliens becoming citizens of South Carolina. Certificate thereof to be given. Privileges allowed to persons having taken an oath of allegiance in fidelity. Provisions as to persons who have not taken the oath. Persons unavoidably prevented from taking it on the day fixed may do so at the courts. And persons not taking the oath banished. Oath or affirmation to the state equals immunity from the lawyer's courts and statutes under their title, State of Florida, of which they have created a nobility under a title within a state for themselves at the expense of the people. The expense that is being spent is the respect that the people have for the law itself, while deceived into respecting the appearance of law for the benefit of a privileged class of people. The privileged class of people, through their devices, have enforced homelessness of millions of people through their creatures of statute, and boast of running the country and making its laws to benefit a privileged few in front of the view of the public. Therefore, through their destabilization and multiple human rights violations, have declared themselves a national security risk, and therefore have knowingly and willfully caused the national security breach and contempt of every constitution and the Articles of Confederation of 1781 as amended August 5th, 2015. Presented by the government of the United States of America. Comments?
So they've created a little club that requires membership, and they've spent lots of money convincing people that aren't in their membership that they have to answer to the membership rules and regs. Then when they solicit for business and they bring you into a court, you walk into what you think is a particular court building, but the bureaucracy within it, the courts operating within it, the paperwork is of their little membership club. Does that about sum it up in common language?
It's within the scope, or they call the scope of their statutes. So what they do, guys, is this. They'll sit back and they cover every little aspect of everything. And that's why you have all these studies going on and statistics and all these things that keep coming up. So they have control and they don't want to lose control. And they know the people can't figure it out. People will come up, bring Constitution in and all that, and all of a sudden they're sovereign citizen domestic terrorists and they're going to jail. Okay? Blah, 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 blah. Those people are correct in their belief, but they have a hard time intellectually imparting it to make their point. And the lawyers take advantage of that. And a lot of that is done in the schools. That's why they don't want people to read. They don't want people to comprehend anything that they read. They do not want people to understand it. They'd lose power. Now, if you really had real power, you would never fear of losing it. Nothing would ever be a threat if your power was real and if your authority was real.
Agreed, right, exactly.
That's right.
Which is why they have to layer upon layer upon layer upon layer the deceit.
Yeah, and when you have a deception, then you're always afraid of losing your power. Everything's always a threat, and everything's always this, that, and the other thing. You know, and you always have to look, you know, over your shoulder. You're always checking people out. You're sending people over here. You know, hey man, what did they say? What did they do? You know, this kind of thing. What's going on there? Is there any, you know, because you're checking out. Is there any more threats over here or over there?
Oh, you mean like an intelligence network? Like infiltrating, liberty groups and things?
Yeah.
Mm.
Which, if you had true authority, you wouldn't have to do that, would you? So, anyways. Okay, do we have time to go through number 2? I thought we might get to 2 and 3, but this actually was a little deeper than I remembered.
Yeah, we might have time, but I don't know if we've got the intellectual capacity. My mind's been blown.
Okay.
You know, it's kind of up to you. I think that's a good dose for people right now. You know, we might spend a couple minutes attempting to give examples or, you know, enrich what we've already covered. But I think that's a lot to chew on.
It's a lot to hit.
Yep.
Okay. Well, go ahead, Tony.
I was just going to ask if there is a way that maybe we can get feedback from listeners and, you know, feel it out, see how they are taking the information, especially those who have never heard of private membership associations or didn't know that how important the style of the name is, whether it's upper, lowercase, how it's, what its legal registration is. And after listening to these past radio programs, you know, you have enough information to get all these threads and put them together. So I just wanted to know if there was a way to get a pulse, I guess, of what the audience is thinking. We
get comments on YouTube, and they're actually very good. A lot of them are very good comments. We get a lot of people that listen to this over and over and over. And then they come through and they'll make, you know, certain comments and everything as if they were in the middle of a thought.
Yeah.
You know what I mean?
Yeah.
They're in the middle of it, you know, and they just start going, start going crazy. And they'll, not crazy, but they get excited, I guess. And yeah. It's like they're talking to a ball game on TV, you know. They're talking
right.
in the middle. So they comment right in the middle of something, and you're like, I have no idea what he was saying, man. I just, you know, was this a question, or was somebody just, you know, writing something down here? Okay, actually, number 2 is a little bit shorter. We can actually do that, and we have links to all these guys if you want to go through this. Let's go through 2 pretty quick because it just gives examples in other states. Okay.
All right.
This is National Security Breach by Creatures of the State, Part 2. In part 1 of the series of presentations, the subject matter consisted of titles and nobility, and now a nobility has been created within a title. Part 2 will expound on some of the very slight changes that have been made to achieve the secular nobility of a privileged class of people within America. We are going to use some examples of documents from the state of Maryland. The state of Maryland is just an example because this sample, or the same example, exists within all of the states of the Union. Now, in 1867, and before the style of the enactment clause for the state of Maryland is this, be it enacted by the General Assembly of Maryland. Example document from that period, and there's the link there. It says that if they wanted to extend sections to enactments, they would write further, be it enacted, and be it enacted, which is an addition to existing law. So that's when you're writing a document. So you'll say, being enacted by the General Assembly of Maryland, and then you'll say, if you want to put in, if you have another law, you'll be further being enacted, or and being enacted. So that's an extension of an existing law. Okay, so in 2004, it all changed to this: being enacted by the General Assembly of Maryland, all uppercase letters. That wasn't like that before 2004, but no one was paying attention. They slipped it in there. And the explanation for the all caps is an addition to existing law, linked to the proposed bill. Because they don't bother to place the actual statute on the internet, the state of Maine is a good example. People are supposed to accept this document as a statute, and there's a link there. Okay, matter of fact, let me go to this link and see what it is. Oh, International Trade and the Economy, Maine Revised Statutes. Commission means, Citizen Trade Policy Commission and all that. Oh yeah, this thing doesn't even have a. There's no act. There's no enactment clause on this. That is an example of a creature of a statute. In other words, when there's no enactment clause when it's published, being enacted by the general, whatever, that's a creature of statute under some other title somewhere. It's a mess. So how is anybody ever supposed to understand what's going on? But I'm sorry, the privileged class of people know what's going on.
They'll take care of it.
Yeah, they'll take care of it. I feel better. I can go fishing, It says, it has been witnessed that all states have changed the enactment clauses to all capital letters. Caps in English descend directly from the Latin alphabet. Okay, so why place a Latin alphabet in an English document when there are no exceptions for all capital letters in an enactment clause, nor in 8 rules of capital letters in the English language? Okay? So when anyone enters a foreign language into any document, the subject matter of the document becomes foreign. Therefore, a foreign state is being created in a state. Example, a copy of the 1867 Constitution of the State of Maryland. In the Declaration of Rights, it reads, "We the people." Yet when it is amended in 2015, it now reads, "We the people," all capital letters. And by the way, did anybody know that it was amended in 2015? That wasn't even in the newspaper. Nobody knew that the state of Maryland amended their Constitution. And we've seen examples of this all over the country. The constitutions are being amended everywhere. But no one's saying a word. It says, now we the people are under a foreign language of Latin and place themselves into a foreign state from the original state of Maryland. Then absorb the original courts into the circuit and district courts. The official language of the United States is English. So it goes even further that the same privileged class of people are also sticking bills to the people of the state of Maryland without their consent under Chapter 239 of the Acts of 2001, Section 1, Paragraph 1. So they're creating a state within a state by statute and then spending whatever money they want and sticking you with a bill under state tax laws. So this is called slavery and or forced labor after the act of trafficking of persons to a foreign state. It's all done on paper. That's why nobody notices it. You weren't brought from one border to another. You weren't thrown in a truck and tied up and brought somewhere else. That was all done on paper.
Yeah, and the only trafficking you ever get exposed to in the news is the physical, abductions and things like that. Nobody ever talks about the bureaucratic trafficking.
It says further, if the privileged class of people desire their own foreign state, it is a violation of the law of nations to attempt to use the former state or any of its people to pay their bills. It comes in what are sovereign states. Every nation that governs itself under what form soever, without dependence on any foreign power, is a sovereign state. Its rights are naturally the same as those of any other state. Such are the moral persons who live together in a natural society, subject to the law of nations. To give a nation a right to make an immediate figure in this grand society, it is sufficient that it be really sovereign and independent, that is, that it govern itself by its own authority and laws. Further, an unequal alliance has been established by and between we the people and we the people, all caps, as written in Section 5 of the Law of Nations, states bound by unequal alliance. This situation would mean that the privileged class of people would be responsible for their own debts. Therefore, the privileged class of people are responsible for the state and national debt. Further, every time the privileged class of people enforce their foreign laws against the people, that would be considered human trafficking, forced labor, kidnapping, theft, unlawful imprisonment, unlawfully detained, and a host of other crimes, too many to list here. The so-called corrections in their private detention centers benefit a privileged class of people because they're sticking the bill for their services to the original state of Maryland. We, the people of the state of Maryland, are being subjected to the privileged class of people's laws that do not apply to we, the people of the state of Maryland, because they are written in a foreign language. This mess all started with the cause of pleading for another for a fee. It all started right there. Let's explore some speculations. This is almost over, and we'll go ahead and end the show for today, because it's going to be hard for a lot of people to hear. I do agree with you there, Stu. It's going to be rough. What if those same privileged class of people were looking to replace the existing slave pool with Muslims? Further, FEMA camps were built to exterminate the current slave pool and replace them with the Islamic slaves to work in the factories and extend profits. Slavery is legal in Islam. This same privileged class of people are not familiar with building nations within nations or states, within nations or states within states, where Islam is a foreign nation to the United States and is strictly forbidden from establishing itself in the United States. So how are they here legally? Well, they're here under a creature of statute. That's how they're here. That appears to be the original state, but it's not. Because it appears to be lawful. So think about the police officers that pledge themselves to uphold state statutes and place their lives on the line every day thinking they are serving the original state, when in fact they are serving a foreign state to the detriment of their own families, possibly themselves and everyone they know today. We can go further with this line of thinking, however. It would be redundant to do so. There will be people that would say that differences in wording does not mean anything. However, it does mean something in documents that pertain to the law. Thank you for listening to the T-Row Show. If you share this with your friends, warn them that they may need a few drinks before they listen, or some on hand.
Or after.
Yeah.
You know, I would also encourage those who are listening to actually go to the Reign of the Heaven Society post and find the Creatures of State series of articles, because when you're hearing it, you would probably understand it a lot better if you read it, so that you can see the difference in the styling of the names. So when you hear the United States and the United States, when you see it, you'll see what the difference is, because when you're talking about it, you're not able to see that difference. So I highly encourage you to read the article, and that would also help you understand the forthcoming articles on that.
Okay, we'll go ahead and put a link at the bottom on YouTube. And the other one, just go to reignoftheheavens.com. That's reign, R-E-I-G-N, of the heavens, HEAVENS.com. And in the search at the top, just put Creatures of the State, and it starts at actually starts at part 8. You'll have to go all the way down to the bottom of the page. It does everything in reverse.
That's right.
Okay, so thank you for listening to the T-Row Show with your hosts, Keith, Tony, and Stu. And we do appreciate your listens, and we do appreciate your those subscribing to the YouTube channel. And we'll see you next week with possibly 3 and 4. We did go through 1 and 2 today, and hope you enjoyed the program. Say goodbye, fellers.
Talk to you next week.
Thank you for listening. Pay attention to entity names.